Welcome, everybody, to the daily summary of the murder trial of Christopher Schurr over the death of Patrick Lyoya. So on April 4th, 2022, Grand Rapids police officer Christopher Schurr, who happens to be white, made a traffic stop of Patrick Lyoya, who happens to be black. Lyoya was passively non-compliant from the start of the stop and quickly escalated to violent resistance. Ultimately, Schurr and Lyoya would be on the ground fighting for control of Officer Schurr's taser when Schurr finally pulled his service pistol and shot Lyoya in the back of the head. Now, more than 3 years later, the defense fired. Officer Schurr is on trial, charged with murder in the death of Lyoya, and we've just had the third day of those proceedings. And it was not a great day for the defense, mostly because of the defense. The defense seems remarkably low energy, unprepared, uncoordinated, unable to put together a cohesive narrative or story arc in their questioning of witnesses. And this was supposed to have been their day. This morning, the state rested with their last witness, and we had 5 witnesses for the defense. And they largely were not all that productive. Largely, again, due to what I would consider a very ineffective defense by Officer Schurr's legal defense team. Now, the first witness of today was a state witness. He was a carryover from yesterday, Nicholas G. Bloomfield. He wrote the expert use of force report for the state along with his colleague, that hack, Seth Stoughton. And they just seem to make crap up. They seem to have a very academic book learning of use of force, use of tasers. They say things like foot pursuit should not be allowed if you go past the front bumper of the suspect's car, that the taser could not have been a weapon in the hands of this violent suspect capable of inflicting death or serious bodily harm. Just nonsense testimony from both Stoughton and Bloomfield. On the other hand, the defense did a very weak job of cross-examining both of those expert witnesses for the state, including this morning with Nicholas Bloomfield. Then the state rested. The defense asked for a mistrial based on the testimony of Seth Stoughton and Nicholas Bloomfield, the use of force experts for the state. And in absence of that, they asked for a directed verdict of innocence, of not guilty for their client. And of course, this judge, who's been very biased against the defense throughout, denied both of those. And the defense began their case in chief. First, they brought up their first witness was Mr. McFarland, forensics video analyst. He did a lot of synchronization of the different videos here, the dash cam, the body-worn camera, the passenger cell phone video. But strangely, remarkably, the defense began to use their direct examination of him to actually create new exhibits, like do screen captures of images in the courtroom. All of these exhibits should have been prepared months ago, if not years ago. There's been a 3-year wait for this case to come to trial. It is insane that the defense is creating their exhibits in real time in front of the jury, in front of the judge. And the state finally objected, and the judge objected. You're wasting court time. Get this guy out of here. Have him develop whatever exhibits you need offline, and then you can recall him and bring him in when it looks like you have your shit together. So that was terrible to have happen in front of the jury, and there's no excuse for it. Why weren't these exhibits ready? Again, they've had 3 years to prepare. It goes along with what seemed to be a very unprepared and unfocused opening argument by the defense, which I replayed during the lunch break today. Lots of staring at iPads, looking down and reading, very unemotional, very unconnected, no narrative arc, very poorly done opening statement by the defense. And the defense team just seems to be relatively unprepared, unorganized, asking questions that seem to be purposeless or don't have any point or don't contribute to a narrative of innocence. It's all very bizarre. And if I were Christopher Schurr, I'd be pretty damn upset. I would quit the legal profession before I presented a defense like this, I have to say. Then the rest of the witnesses for the defense today were all police officers from the Grand Rapids Police Department, one of whom was retired. The first one they brought, Sergeant Timothy Johnston. This guy looked like he couldn't even brush his hair. before appearing as a state witness. Otherwise, his testimony was fine, except on direct examination for all of these. I'll just list all of them. Defense witness 1 was a video expert. Defense witness 2, retired Sergeant Timothy Johnston, who can't brush his hair before coming to court. Defense witness 3, Sam Mott, another Grand Rapids Police Department patrol officer. Defense witness 4, Nicholas Colati, Grand Rapids Police Department. Defense witness 5, who will carry over to tomorrow, the last witness of today, Captain David Zyver. And all of these, the direct examination by the defense seemed meandering, pointless, not building any kind of narrative to ultimately be sold to the jury in a closing argument. Sometimes the state didn't even bother doing a cross. That's not a good thing. That means you did no damage to the state with that witness when the state doesn't even want to bother cross-examining the witness. So I thought it was very much a weak sauce defense direct examination of their first handful of witnesses. By the way, this trial was supposed to go 2 weeks. The state really only presented for 2 days, Monday and Tuesday. Part of Monday was opening statements. Wednesday morning, they wrapped up their last witness. They rested Wednesday morning. So I would characterize that as 2 days of testimony by the state. I don't think the defense has a week and a half of testimony in them. I certainly hope not, given how they're doing it so far. So this isn't going to be a 2-week trial, I wouldn't expect. I expect this trial will wrap up this week. So all these witnesses that the state presented for its case in chief, most of them were police officers. This should have been huge. Why aren't the police officers testifying for the prosecutor? Why are they all testifying for the defense? And yet the defense seemed to get very little out of them. What they did get, they never contextualized back to their defendants' conduct during these videos. Captain David Zyver, the last witness today, seemed to be going the same way. But 20-year officer, captain with the police department, lots of training experience, very calm demeanor on the witness stand, very credible, appears to be extremely honest and open in his replies, not evasive in any way. And the first hour of direct examination of him by Michaela Hamilton, who did the opening statement, seemed rather pointless. It seemed like a dry academic lecture on the use of force policies of the Grand Rapids Police Department. And it was very dry because there was no indication of why we were learning this. There was no connecting it back to the videos, back to the actual use of force event. It was like the jury were recruits in the police academy being lectured on use of force policy that may or may not be relevant to them someday in the future. With no context, the jurors have no interest in these policies. Their mission is to be finders of fact in this case, and there was no connection of the policies to the facts of this case. Now, after about an hour, it might have been an hour and a half, it felt like 2 hours, Michaela Hamilton did begin to show videos and tie the policies back to the videos, which is what she should have been doing. Now, there's not a problem with her saying, let's cover the policies first and then tie them into the videos after we've done kind of an initial look at the policies. That's fine. But then when she was doing the initial view of the policies, she should have told the jury, indicated to the jury, by asking the captain, what I plan to do is ask you about the policies first, and then we will tie it all back in to the videos. Well, then it looks like it has a purpose other than some kind of academic education in the Grand Rapids Police Department use of force policies. There's a reason we're doing this, and the reason will become clear in just a moment. Nothing like that was communicated to the jury. We were all falling asleep listening to that first hour and a half testimony from the captain, especially since defense attorney Michaela Hamilton's demeanor, it's like she's on some kind of depressant medication. The energy level is like a 2. It's as if she doesn't care. It's as if her questions don't string together. It's as if she were reading a list of someone else's questions. It's as if she were engaged in a bring your police captain father to school day and interview him about his job, and she doesn't actually care about the answers. She just has a list of questions she's required to ask, so she asks it, ignores the answer, and then asks the next question and ignores that answer because there was never any follow-up. There was never any digging in. When the captain would say something important and worthy of emphasis and repetition from different angles, she just wouldn't do that. She would simply transition to the next question. You could literally have grabbed a woman off the street and had her perform that first hour and a half of direct examination of this very important defense witness, because this captain is very favorably disposed to the defendant. Many times it felt like the captain was feeding her answers that were important to Christopher Schurr's defense, hoping desperately that she would focus in on it, dig in, ask more, follow up, ask the question again from different angles for emphasis, and she never did. She just skipped right over to the next one. But after about an hour and a half of this dry direct examination about the policies, that she did begin to bring the videos in, and it did begin to make more sense. It would have been nice for her to have foreshadowed that an hour and a half earlier. So now we've been going through the videos. She basically ran through all the videos from beginning to end. And in each step, she kind of asked, was this appropriate for a police officer? Although she didn't do that enough. She didn't do it with enough emphasis or enough repetition. She still seemed to be doing a task she just wanted to be over. Even with the videos, it was a very poor performance. Very disappointing. When a man's life is at stake, life in prison is at stake. And then shortly before the end of the day, the defense rested with this witness, and Prosecutor Becker, Kent County elected prosecutor, began his cross-examination of this police captain. And it was a Binger-like cross-examination. Lots of loud voices, lots of mocking, lots of throwing papers around, approaching the witness without asking the judge for permission to do that, which is rather inappropriate. Conduct the defense the judge would never have let the defense get away with. And a lot of sarcasm. Don't you follow this policy from this other agency and this policy from Police Magazine? Frankly, a very unimpressive performance. Now, as negative as I've been about the defense team, the prosecutors also been very unimpressive throughout this trial. That's not an excuse for the defense team to be bad. And Prosecutor Becker was not impressive on his direct examination of the captain. Now, that direct examination by the state lasted only for a few minutes. I'd say maybe 10 or 15 minutes. And then the judge called it for the day. It was getting to be close to 5 p.m. And she recessed the court for the day. So we'll be coming back tomorrow, continuing the direct examination of Captain David Zyver by the state. I'm not sure I have much more to add to all of that, except join us tomorrow. We'll be starting up at 9 a.m. Eastern Time for day 4 of the Christopher Schurr trial, live streaming it all day. Maybe I'll have some guests come in, maybe not. Depends on what people are interested in doing. They're more than welcome as they came in today. David from Making Law Simple came in, and Nick Starro from Starro Law, both on YouTube. You should subscribe to their channels. Both came in and added some commentary and color and fun this morning. They're also live streaming the trial themselves. I think in the afternoons. I think they're doing it at a higher speed of a higher rate than rather the real time I'm doing it in. But that'll be 9 a.m. tomorrow, and probably, you should join us for that. Join me for that here at Law of Self-Defense on YouTube or on Rumble or on X, or if you're a Law of Self-Defense member, of course, we'll be streaming that to the member channel as well. So let me take a look at questions and comments from the day. We only have a couple super chats. When do you pursue someone on foot? Oh my God. Like the state is trying to suggest that it's never appropriate to pursue someone on foot because for all you know, they can have a gun. It's just absolutely crazy. $5 super chat. Thank you very much. And then Dirt Cheap says, I think you need to $5 super chat. I think you need to buy yourself flowers today. Perhaps. I was extremely disappointed in this defense. Very low energy, very unorganized, not incisive, no narrative story arc that's being built, not following up on important questions, not driving home important replies from the witnesses. These are the defense witnesses that ought to be key to the closing argument for the defense. I just didn't see any of that development happening. Important answers were treated no differently than unimportant procedural types of answers. You need to show the jury what to focus on. You need to show them what's going to be important to their arriving at a verdict in this case. You can't just make a gruel and then hope that at the end you'll be able to pick the raisins out. The jury has to be able to see what's important now. What's important now? And they just didn't do that. So, law self-defense members, my take is the captain, that last witness, Zyver, did the real damage to the prosecution case by providing multiple instances of reasonable doubt concerning the way the prosecution's two experts portrayed this incident. That's why the prosecutor came out hot. Well, the Captain Zyver said explicitly, every step was reasonable conduct consistent with the training for the Grand Rapids Police Department. Even the shooting at the end was reasonable conduct of the Grand Rapids Police Department. So, of course, that guts the prosecution's case if the jury believes it and if that opinion is not impeached by the prosecutor, which is why the prosecutor went to energy level 12 when he started cross-examining Captain Zyver. Because to win, he's in it to win it. He's committed to this. I don't see that level of commitment from the defense, certainly not in terms of energy. And the prosecutor's attacking what needs to be attacked, while I don't see the defense highlighting what needs to be highlighted. Let's see. Phil says, my company belonged to several professional organizations, so we got something like 20 to 25 magazines most months. In addition, as a defense contractor, we had subscriptions to maybe another 15, 18 government pubs. No way our senior leadership read all of that. The prosecution is trying to say there's something wrong with the Grand Rapids Police Department because they didn't follow the policy recommendation of something called Police Magazine. And the judge accepted Police Magazine into evidence for impeachment as a learned treatise, like a textbook. It is not a learned treatise. It's a police magazine written by police officers. Learned treatise, my ass. Zakuza says, I think we now know why the judge is so bad. She hasn't paid her subscription fee for Judge's Quarterly magazine, so she's lost on what to do. Maybe the prosecutor feels betrayed by this police captain. Let's see. I don't think the prosecutor's over the top, angry, shouting, ranting, direct examination of this Captain Zyver is going to help him with the jury. I think he looks deranged. So hopefully he'll continue doing that. He was explicitly badgering this witness, interrupting his answers, throwing documents on the table in front of him. It was crazy. Crazy. All right, that's most of the member comments. It doesn't look like there's any more super chats. So I'm going to go ahead. I've only been live streaming for 9 hours, folks. So I'm going to go ahead and wrap up this day. Don't forget, you can get our book for just the cost of shipping and handling at lawselfdefense.com/get the book. Don't forget to hit that subscribe button on your way out. We're getting pretty close to 212,000 subscribers. That would be awesome if we could hit that today. Come back tomorrow morning. Having passed 212 overnight, I'll be back online live streaming this trial at 9 a.m. tomorrow morning. And of course, we produce other content too. So subscribe, hit that bell notification, hit that thumbs up button, and become a member of the Law of Self-Defense community. You will not regret it. That's my commitment to all of you. So until tomorrow morning, 9 a.m. Eastern Time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.